Yes and no. And again, I don't want to bash any district attorneys, but some have the thought of charging a lot of charges to try and
Mhm.
get the deal and work it down to what you really think
Right.
that the charges should be.
Mhm.
And some, like our district attorney now, he really reviews the cases and wants to charge the charges. And when there are over charges, then he asks to amend them, or he states it on the record exactly
Sure.
why it was overcharged.
Sure. Does that have any impact on your when we do stories on the cases or this charge was dismissed but read in? Explain that to people how that process works.
What dismissed and read in is?
Yeah. And what I mean is,
Okay.
in this, well, first of all, explain that for people who don't know. But also, if there's, let's say, those five charges, I think there's like five that you had mentioned during that maintaining drug place, and three of them were dismissed but read in. What does that mean?
Dismissed and read in means that they're going to be dismissed, but they're read in so the court can look at those charges for sentencing purposes and can look at those charges for restitution. It doesn't mean that the defendant is admitting guilt to those charges, but is saying that I understand the court can use those for sentencing purposes. And when they're dismissed and read in charges, some may be there's not enough probable cause to convict them on. Some it may be that it just wasn't a charge that should have been charged. Some could be just part of the plea deal to give that person a second chance if they're somebody new to the criminal system. But dismissed and read in charges mean that once it's dismissed and read in, they can't be charged with that crime again in the future. So if the law enforcement and the DA discover more information and evidence about that dismissed and read in charge sometime down the road, that defendant cannot be charged with that crime again, even if it comes out 1,000% that they're guilty of it. That's different than just a straight out dismissed charge,
Right.
because if it's dismissed on either court or prosecutor's motion, that means that maybe some day down the road, if they find evidence that the defendant is 1,000% guilty, has done all of these things, then that defendant can be charged again with that charge.
All right, we have a question from Carol. Carol, I'm not going to forget you. I want to bring that up, but I want to stick on this here real quick. Is the So when there's a plea deal that is made, and this is something I literally have never known. I've had Judge Yackel on. I love that guy. I don't think I've ever asked him this, but I've always wondered, what do you know about it before it gets presented to you?
With a plea deal, um, and again, there's different schools of thoughts with regards to this. Some judges don't want to know what the plea deal is before you proceed to the plea.
Uh-huh.
I'm on the other side of that. I always want to know ahead of time, okay, what is the offer? Has the offer been accepted? Is this the deal? So then I can get my head wrapped around it with the facts that I have available to me. But generally, before I go into a plea and sentencing, the only thing I know is, for the most part, this is what's been offered and this is what's been accepted, and we're going to argue this to the court. But the facts that I get for a case for sentencing are only those facts that are within the criminal complaint, and facts that I get from motion hearings and arguments from both attorneys.
Do you usually know whether it's a plea deal or it's time for a sentencing? Do you usually know what you're going to do before
I
you
do
hear the
not.
arguments?
I do not. Sometimes I have an idea and I think of what I might possibly do, but I'm going to.
Wisconsin doesn't really use rigid sentencing grids. Aside from DUIs and a few mandatory minimums, judges have tons of discretion. Fair flexibility or room for bias?
A judge can say, I know exactly what I'm going to sentence. I'm going to sentence this person to this for this long, but they're not being a very good judge, because when you're in a hearing, that's where you get most of your information. Like I said, I get all of my information from the criminal complaints, from any motion hearings, from the preliminary hearing, and from the arguments from the attorneys. And sometimes a lot of times, the arguments have all of this information that I was not aware of. and maybe the defendant has not had a criminal history. Maybe this is the first time. Maybe this was a something where they got caught up with an individual they shouldn't have. All of these things come out in the sentencing arguments. And I'm going to tell you, sometimes I go in there thinking I'm going to do one thing, and I do something completely different based upon the information and arguments from the attorneys.
Have you ever run into a situation where even after hearing all this, you're like, okay, this is what I'd like to do, but aren't there like sentencing guidelines? And you're like, oh, snap, I guess I can't do that. Have you ever run into that before?
Yeah, sometimes, but there are sentencing guidelines, but for the most part, the sentencing guidelines are only for the operating while intoxicated, it's the OWIs, or the operating with restricted controlled substances, those types of things. Okay. And when we have like mandatory minimums for some crimes, because there are some mandatory minimums. An operating while intoxicated fifth offense has a mandatory minimum of at least 1.5 years of initial confinement, and you can do whatever the maximum could be on extended supervision. But we don't have many sentencing guidelines in Wisconsin except for those few instances.
Do you think we should, or do you like it this way?
I don't think we necessarily should, because then we're telling the legislature that they can tell the judges what they should or should not do with regards to sentencing. And right now, the judges have a lot of discretion. But again, a lot of it comes from the arguments of the attorneys and the facts. But right now, I have a lot of discretion when I hear cases and I hear things. If I'm told by the legislature I have to look at between 5 and 8 years for a sentence, I could think, well, they don't know exactly the facts of this case, and it should be 3 years, or maybe it should be 12 years. Every sentence is a case-by-case, fact-by-fact basis, if that makes sense.
It does. 2023, I think, was 2 years ago. There's constitutional amendments, I think in an April budget, both of them referring to bail. People kind of get caught up in bail. I do too. I totally do. Like, I run this business at the same time. I can get easily, like, what the frick? That's the only bail that you gave this dude? Are you kidding me? Did that make it kind of allowed you to consider more things, right? When it comes to bail, has that made it easier, harder, better, worse? What are your thoughts on those constitutional amendments?
Well, I actually think that they're better. They give more discretion and authority to the courts to look at the protection of the public aspect and whether or not the defendant could be a risk to the public. Whereas previously, what the court needed to do, or we were told to do, is first look at, failing to appear. We have to ensure their appearance for court. And that's why, quite honestly, you would see a lot of signature bonds in some of the counties, because if they make all of their court appearances, you need to first look at a signature bond. Even if they have 20 convictions behind them and they're serious convictions, maybe a burglary, maybe, possession of methamphetamine, maybe intent to deliver possession of methamphetamine. But if they've made every single court appearance in all of those cases prior to the constitutional amendment, we needed to just look at, well, are they going to come to court? History says they're going to come to court. Well, I guess maybe we need to do a signature bond. But now we get to use our discretion a little bit more to look at.
Dismissed, but read in means the charge is not pursued as a conviction, can't be refiled later, but the judge may consider the conduct for sentencing and restitution. Think of it as a ghost factor at sentencing, visible to the court, invisible on the conviction list.
The actual risk to the public, and if there is a safety risk to the public, and look at, have they been on probation before? Have they violated probation? What type of crime is this? And we can put cash on individuals a lot more easily, I guess, than we could previously.
Yeah. Do you have an opinion on? I personally of the opinion that was good that we did that. Do you have a personal opinion on that?
Well, I can say my opinion as a judge is I like the fact that now I have more authority. I have more discretion in bail and setting cash versus signature.
So I want to go back to this question from Carol. She says, Brad asks, views on Milwaukee Judge Dugan's ICE obstruction case and immigration issues. I'm not even sure where that is at this point. I haven't seen that in the news lately. Obviously, you saw that as huge news. What were your thoughts about that when you saw that story?
Well, I don't know where that is in the process right now, and unfortunately, I do have to say I'm not permitted to answer that question. We've been directed that we're not supposed to give any responses as it relates to that issue.
You know what? I wish I would have had that excuse when I was in school and just said, "I'm sorry, my parents told me that I can't actually speak about my homework assignments and why they're not turned in." See, that'd be great. We should just have one
That
of
would
those.
be great.
Mike Schaefer says, "Doesn't I'm sorry, I missed this, Mike. I'm not sure what we're talking about. Doesn't that discretion create uneven justice throughout the state, allowing some judges to slap a guilty party on the wrist while others may be much harsher? Is that fair to those found guilty?"
And I guess I understand the question. I think it was from Mike Schaefer. I think
Yeah.
that's who I saw the individual was. I understand his question with regards to doesn't that create an unequal balance in the justice system? Well, honestly, to let you know that yeah, there could be some judges that are way off on one side and some way off on another, but I don't think that it does create anything unequal when it comes to the individual. Judges are supposed to, we're taught, we go to judicial college after we're elected. We go to continuing education courses and conferences, things that continue to educate us and update us on the law and the situation, and to do sentencing scenarios with judges across Wisconsin. But again, I have to get back to it's a case by case analysis. You have to look at the defendant, their past criminal history. You have to look at if they have any needs for rehabilitation. You have to look at their criminal record. You have to look at their age, their mental ability, if they have any mental disorders. You have to look at a whole slew of factors when you're sentencing. And I'm going to tell you, that's why I try as a judge to get to know, or to know as much about the people that come in front of me when it comes to sentencing. The more I know about a defendant, the better sentence I can create for the defendant, to hold the defendant accountable and responsible, but also to ensure the public is protected and that there is punishment.
Well, and also, let's face it, judges want more control anyway. I'm just kidding. I'm just kidding. You're a bunch
Well,
of prima
I'm
donnas,
not gonna
I tell
argue
you.
that.
Holy cow. You're so needy. I'm just kidding. You have, I've seen on YouTube, I'm rarely on YouTube, but I've seen that, what is the YouTube thing that I see you on? Like you're just, I can't remember the name of it was. What, is everything just streamed live? Is that where it's coming from the county, or what is that?
Well, some judges do this. Not a lot of judges in Wisconsin do this, but when we went to COVID and we had to figure out how to continue to run our courtrooms, keep our cases moving, and keep protecting the public, Zoom came around, and we were told we needed to start using Zoom, and we needed to start live streaming so that the public can still participate, be a part of the court system without actually having to travel into the courtroom.
Love it.
I am one of few judges. I don't know how many there are in Wisconsin, but I am one of few judges that continue to live stream my courtroom because I want the public to know exactly what.
Does discretion create uneven justice? Some judges go soft, others hammer hard. But in theory, training and case-by-case analysis keep things balanced. What do you think? Fairness or inconsistency?
The court does, and to follow cases and to know those types of things. So I live stream it with it's our County Burnett Circuit Court YouTube channel, but I delete them. I don't share them. I don't try and get subscribers. I don't try and get ads. I don't know exactly how people bootleg or take my videos and put them out on their own sites and things. I'm just not that tech savvy, because in my YouTube settings, I have it so people can't download or forward. So I don't know how it's done, but What I do is I live stream it and I delete it within a day or 2 days, unless I forget. And so that's how my court is out there. But again, I don't know how they're posted on.
Okay, yeah. So there's
YouTube
two
and
different
stuff.
ones. I get it now. Okay. Because there's another one, and I'm only picturing in my mind's eye a whole bunch of neon green writing. And that's all I remember is just a whole bunch of neon green writing on things. So somebody else will take it, and then is it usually like good or bad? I mean, is it complimentary, or is it like
I don't
what's the
know.
point of doing it? I mean, is it just like repurposing it, or just taking clips?
Well, sorry to interrupt, but people take all of the court hearings, and it's not just with my court. I'm originally, well, I'm not originally. I'm originally from Gwinnett County. This is where I was. I went to law school in Michigan. I practiced in Michigan for a long time, so I know a lot of people there. I know judges there. Some of the judges I'm friends with, and I knew back in Michigan, they live stream as well. So lots of judges do it, and sometimes people make the videos and they do things to them, or they put on a funny hat on me, a cartoon hat or something like that, or they just stream the videos and they let the public watch. Sometimes it puts the court in a good light, sometimes it's not. Of course, everybody has their opinion. The public is welcome to their opinion, but I don't necessarily know if it's good or bad. I'm not going to control it. See, that's one of the things that I'm not going to control it. I'm not going to take offense to it. I'm not going to be hurt by somebody posting something. It's just my job.
Yeah. If you weren't doing this, what would you be doing?
Oh, I always say when I'm not going to be a judge, I'm going to work at Quick Trip. That's my favorite job.
Why? Is any particular reason Quick Trip, or do you just love Quick Trip?
Well, Quick Trip my heart and soul is in baking. I actually went to culinary school for a year prior to law school. That's where my heart is. But Quick Trip, because it's an amazing company, and I've known that since I was in college, because of my uncle and his business, and he would tell me from when I was in college how Quick Trip is such a great company. They have great benefits. They're very personable. They have great food, and they're only geting better.
Dryden Live,
So Quick
presented by
Trip
Quick
wants
Trip.
to come to
Yeah.
what?
I said Dryden Live, presented by Quick Trip.
Yeah.
Oh, well, hold on a second. Looks like I think they found a workaround here, maybe. Brad, follow. What are your personal and professional views on immigration and deportation of those here illegally? Can you answer that?
I love the question, but judges, we are impartial. I cannot even take political stances anymore. I can't put out political signs in my yard. I can't help any politician run for an office.
Well, that's
I
smart.
can't even express.
I mean, even if you could, you
I
shouldn't.
can't even
Right.
if I could, I shouldn't. I'm not even supposed to ethically express my political views because the Supreme Court can. They're one of the few that can do those things. But circuit court judges and appeals judges, we're ethically bound from discussing that because we're supposed to be impartial. We are impartial, and we're not supposed to use our position and clout to try and persuade others politically.
What's the point of having the position and all that clout if you can't use it? Just saying. But it's a
Well,
good
you can
gig,
use
but
it for your job and your profession.
I suppose. What are some of the fringe benefits of being a judge? I don't know, you get your own parking spot or something? Free coffee? What do you get as like fringe benefits?
Yes. Well, parking spot is one. Yeah, we can get a parking spot, and that's great. The parking
Nice.
spot is more for knowing exactly where your car is at all times. Some of the benefits, I get
Wait,
to
hold on a
control
second.
my
I was using that as an example. You literally do have your own parking spot?
Yeah, I
didn't
think
know
most judges do.
Oh, I
Yeah,
actually.
some judges even get. I know a couple counties that have pull into garages where the judges get to go.
Okay, no, if for a safety standpoint, that actually I totally get that. I really, really do. But then again, like if I were a judge, I wouldn't want my own parking spot. I wouldn't want people to know when they're walking out and I just ruled on something, like that's the judge's car. Just saying. I probably wouldn't want
It's
my own.
protected by like 20 cameras, and it's it's in a restricted area.
Oh, okay. I'm sorry. Continue. Other like fringe benefits, as it were, things that like I really enjoy this because I love those things in life.
I get to control my calendar. I get to control my life. Granted, I am a very high caseload county, but if something happens and I need to not be there, I can move cases. I don't like to do that because people wait months and months to get on my calendar. So that's only in an emergency and urgent situation. I don't know. I get to control my job and how it functions and how it flows. I get to work with some really great people throughout Wisconsin, some really great judges, some really great attorneys. That's a perk to me.
Does Burnett County, according to Judge Yackel, back when they were still a one county judge, he sent me this, I don't know if it was a website or PDF or something, and it would show like caseload. And I don't remember what this was called or what it was. It just kind of divided it all out, and it's per judge. So it's not just for judges in single judge counties. And he was like consistently number one or number two. That's why they ended up getting another judge in Sawyer County, or one of the factors that went into that. Burnett County and Sawyer County are roughly the same size, different situation in both. But do you think Burnett County needs a second judge? Should that ever even be entertained by the state?
It's called a caseload summary, and
That's
it looks
what it
at a judge's caseload throughout a period of time. I have historically been very high since I started back in 2017. Right now, Burnett County is number 3. We're tied with Trempealeau on the third highest caseload out of 72 counties in the state of Wisconsin. You're right. Sawyer County no longer is, because they were blessed to be able to get Judge Isham along with Judge Yackel. And so now they are a lot lower. I don't think they are even close to needing anything more. But in order to get the ability to have a second judge, you have to be high on that